is unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings, in this case on the Molyneux issues?
Well, parsing the Molyneux evidence, no one would quibble with the admissibility of the uncharged offenses as to Mann. Ample case law, which
I'm talking about the other three women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent.
So you're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I see no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let one or two in. I mean, there is a balance.
But looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario.
30 non-convicted, and they're not convictions, not one of them, acts. That's balance?
Well, as you point out, the fact that they're not convictions, that they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative of...
Were you recently injured in a car accident? Look at this check for $160,000. If you're looking to get money you're owed for an injury, I want you to imagine you and your family.
How defendant lived his life, the court was not required to unduly sanitize that.
Which proves the point. You're saying this is just him. He's a bad guy. There's a lot of acts because he's just bad. So, to say it's indicative of how he lived his life, he doesn't get convicted because he's a bad guy. He gets convicted for these particular crimes.
This clip was captured from a different appellate case altogether, but we chipped it in so we can understand exactly how